At 1:52 on a gray Thursday afternoon, Daniel Voss walked into federal court dressed like a man who still believed sentencing would end with a lecture, a reporting date, and maybe a few months of home confinement in a gated house he had spent years calling modest, with a straight face. By 2:19, deputy marshals were taking his watch, his belt, and the contents of his pockets in a holding room behind the courtroom because the judge had revoked his release on the spot. The fraud conviction was already serious. The money was worse. But that was not what broke the hearing open. What changed the room was an orange plastic storage key, a grainy elevator still from a self-storage facility across the river, and one question the judge asked in a voice so flat it sounded almost polite. I have spent decades around federal courtrooms, and one thing you learn early is that the most dangerous moment for a defendant is not always the verdict. Sometimes, it is the moment after everyone thinks the damage has already been counted. That is when the government shows you what it was saving. Daniel Voss, 51, was the founder of GridCorps Response, a private contractor that made a fortune selling emergency power units to counties after storm disasters. The government said the company did not just overbill. It said Voss manipulated procurement bids, used shell vendors to inflate maintenance costs, certified dead equipment as field-ready, and kept cash flowing by making sure local officials saw glossy compliance binders instead of the truth. By the time the jury convicted him on 12 federal counts, including wire fraud, false statements, and conspiracy, the defense had already shifted into damage control. He was a first-time offender, nonviolent, stable address, family support, medical complaints, all the usual words that should have made the hearing predictable. It did not. His lawyers came in asking for time before surrender and pushed hard for home confinement pending final designation. They talked about his age, his charitable donations, his church letters, the employees who still depended on him, and the fact that he had appeared for every hearing. Voss sat at counsel table with both hands folded over a yellow legal pad, nodding at all the right moments. He looked exactly like the kind of white-collar defendant who believes professionalism can still organize reality after a conviction. Then the prosecutor stood. Not dramatically, not loudly, calmly. That is usually worse. She said the government had an emergency application to revoke release immediately based on post-verdict conduct, newly recovered physical evidence, and what she called an active effort to move documents beyond the reach of probation and the court. The defense objected before she got through the sentence. The judge held up one hand, looked down, and said, "I'll hear it." And just like that, the hearing stopped being about how Daniel Voss would serve his sentence and became about whether he was leaving through the front doors at all. The first thing the prosecutor did was not play audio or call a witness. She held up a clear evidence sleeve with a bright orange plastic key attached to a small white tag. It was the kind of storage key people barely notice because it looks too ordinary to matter. That was the point. The room leaned in because nobody expected a cheap little key to become the center of a federal sentencing hearing. She told the court it had been recovered from the inside pocket of a garment bag seized from Voss's driver after a consent search that morning. Not from Voss himself. From the driver, and the tag number matched a storage unit rented 3 days after the guilty verdict at a facility in Newark under the name of Voss's wife's cousin. That alone was damaging. The next part was worse. The prosecutor said the rental had been paid for with a cashier's check purchased in cash. The surveillance logs showed the unit had been accessed twice after midnight and once at 5:33 in the morning. On both dates, the entry system recorded the same unit number, the same orange key, and the same freight elevator. Then she handed up still photographs. In one of them, a man in a baseball cap pushed a flat dolly loaded with banker's boxes toward the elevator. In another, you could see enough of his face to make the identification problem disappear. It was not Daniel Voss. It was his longtime operations director, Reed Talbot, who had testified for the defense at trial and sworn that all responsive company records had already been produced. Up to that point, Voss still looked composed. Then he stopped writing. The defense tried to interrupt, saying they had not seen the photographs, had no way to verify identity, and had not been given a foundation for the claim that the unit had anything to do with their client. The judge let them talk for about 15 seconds and cut it off. "You'll get your turn," he said. "I want to know what was found." That was the right question, and the prosecutor was ready for it. Inside the unit, she said agents executing a fresh warrant had recovered 4 banker's boxes, 2 external hard drives, a backup phone wrapped in a microfiber cloth, and 3 label folders containing procurement files that had not been produced in discovery. One folder was marked Field Readiness. Another was marked County Renewals. The third had only initials written in black marker on the tab. Those initials matched 3 trial witnesses. The hearing looked routine. Then the room changed. The prosecutor moved quickly because she understood live courtroom gravity. One beat, then the next. From the field readiness folder came inspection sheets showing generators had been certified as operable on dates when internal service logs recorded them as dead, stripped, or awaiting replacement parts that had never been ordered. From the county renewals folder came side-by-side copies of invoices. One version sent to public clients, another version kept internally with lower true costs and handwritten markup instructions. On one page, the jury had already seen Voss's initials. On another page, recovered from the storage unit, there was a new notation in blue ink: destroy after rate reset. The defense lawyer's face changed at that line. Not panic. Worse. Recognition. And then the prosecutor came to the backup phone. She said forensic review was still underway, but they'd already extracted message fragments from an encrypted app. Several were incomplete. One was not. It had been sent at 11,018 p.m. The night after the verdict from an account the government linked to Voss through device mapping and office Wi-Fi logs. It read, Bay 14 first. Pull the old binders and anything with Palmer, Givens, or Soto. Do not bring phones. Palmer, Givens, and Soto were the 3 witness initials on the third folder tab. That should have ended it. It did not. The defense said fragmentary messages prove nothing. They said Bay 14 could refer to a warehouse lane, a loading area, any number of innocuous things in a logistics company. They said there was no proof Voss authored the message, no proof he knew about the storage rental, and certainly no proof he intended to obstruct anything. His lawyer insisted that after a high-profile verdict, people around a defendant often act on their own, trying to help without instruction. That was the best defense available, and it lasted about a minute, because the prosecutor had one more witness. Not live, not in person. By stipulation for the limited remand issue, the court accepted a summary proffer from the storage facility manager and an affidavit from an FBI case agent. The manager identified Reed Talbot from the surveillance stills and stated that the second man seen with him during the first overnight visit wore a surgical mask and cap, but arrived in a black Escalade registered to a company trust controlled by Daniel Voss. The agent's affidavit added something smaller and more destructive. The gate log reflected that whoever entered the facility used the orange key and then called the help desk from the number listed on the rental file when the freight elevator stalled. That phone number belonged to Voss's executive assistant. From that point on, every answer made the next consequence easier to see. The judge asked defense counsel whether they disputed that the unit existed. Counsel said no. He asked whether they disputed that company records were found there. Counsel said they had not examined the materials personally. He asked whether they disputed that the rental occurred after conviction. Counsel said the timing appeared accurate, but the purpose remained unclear. Then the judge looked at Daniel Voss. Not for effect, for information. Mr. Voss, he said, were you aware that records tied to trial witnesses and internal billing files had been moved to an off-site storage unit after the verdict in your case? Defense counsel was instantly on his feet, asking for a pause, asking to confer, asking that his client not be questioned directly. The judge let them huddle for maybe 20 seconds. Voss leaned in, whispered, straightened, and nodded. Then he answered, No, Your Honor, I was not. It was a clean answer, too clean. The prosecutor did not challenge him immediately. She reached for one sheet of paper, asked permission to approach, and handed it up. It was a visitor access log from the federal courthouse garage the morning after the verdict. Voss had signed out at 8:07 a.m. His destination line, written in a hurried block print, read, Bay 14 Warehouse. The defense said it proved only that he had been to one of his own properties. The prosecutor agreed. Then she told the court Bay 14 had not been one of his operating warehouses for almost 11 months. Its commercial lease had been terminated. The only active Bay 14 linked to the company ecosystem was Unit B14 at the storage facility in Newark. That was the moment the room lost him. You could see it physically. Voss's shoulders, which had been square all afternoon, dropped a half-inch. He pressed his lips together. His right hand moved toward the water glass and stopped before touching it. His lawyer started writing harder, faster, as if speed could still manufacture an exit. Then came the one question he could not answer cleanly. The judge lifted the orange key in its evidence sleeve and asked, if this unit had nothing to do with you, why was the key in the pocket of a garment bag being carried this morning by your driver, who works for you after your conviction on the day of sentencing? That question did not leave much room. Voss tried anyway. He said the driver handled multiple bags, multiple residences, and sometimes moved property for family members. He said he had no idea what was in that pocket. He said people around him had been doing things since the verdict without keeping him informed. He said the entire situation was chaotic. Chaotic is a bad word to use in federal court when the government is arguing you cannot be trusted with release conditions. The prosecutor stood again and delivered the final blow in 3 sentences. First, the driver had told agents he picked up the garment bag from Voss's home office closet that morning. Second, the cousin on the rental contract had already admitted she never rented the unit and allowed her identity to be used because she was told it was for overflow legal materials. Third, the hard drives recovered from the unit appeared to contain accounting exports created after the trial record had closed. This is where the hearing stopped being theoretical. The judge did not speak for several seconds. He looked at the papers in front of him, then at Voss, then at the orange key again. When he finally ruled, he did it in short sentences. I do not credit the defendant's explanation. I find by clear and convincing evidence that release conditions have been violated. I further find probable cause to believe the defendant engaged in conduct designed to conceal, move, or withhold evidence relevant to sentencing and possible further proceedings. Release is revoked. The defendant is remanded immediately. No flourish. No lecture. Sometimes the flat rulings land hardest. The chair scraped first. That was the sound everybody heard before they processed the words. Then one of the deputy marshals stepped forward from the sidewall. Voss turned toward his lawyer as if there might still be one more sentence left to argue over, one more procedural ledge to grab. There was not. His wife, in the second row, put a hand over her mouth. Someone behind her whispered, "Oh my God," loud enough for half the gallery to hear. Voss stood slowly. Not defiant, not dramatic, just slower than a man stands when he knows the next place he is going is not his car. A marshal instructed him to place his hands behind his back. He hesitated for maybe half a heartbeat. Then he did it. The cuffs went on tight and close, hidden partly by his suit jacket, but the metallic click still carried farther than people expect in a quiet courtroom. That sound always changes the meaning of everything said before it. A man who walked in, expecting terms of surrender, was now a remanded federal prisoner awaiting transport because the court no longer believed he would preserve evidence, obey conditions, or tell the truth cleanly when it mattered. The legal reality after that moved fast. Once a defendant has been convicted, the presumption shifts hard against continued release. Add post-verdict document movement, possible witness-linked files, a backup phone, and misleading answers in open court, and the argument for home confinement collapses almost on contact. The judge did not need to decide every future charge that afternoon. He only needed to decide whether Daniel Voss could still be trusted outside custody. After that record, the answer was no. And the cuffs were not the end of the damage. They were the start of it. The contents of that storage unit now matter in at least 4 separate ways. First, anything not previously produced becomes sentencing poison, because concealment after conviction suggests consciousness of guilt, not remorse. Second, the witness labeled folder raises the possibility of tampering, retaliation planning, or at minimum, an effort to track and manage exposure tied to trial testimony. Third, the hard drives create forensic risk far beyond paper records. Metadata can show when files were exported, renamed, copied, or deleted. Fourth, the backup phone opens an entirely separate lane of proof because message recovery often gets cleaner as specialists work through cache data, linked devices, and cloud fragments. That alone would be enough to deepen the hole. The next part is worse. If prosecutors can show Voss directed the post-verdict movement of records, he is staring at potential obstruction exposure on top of the sentence already coming for the underlying fraud case. And even if no superseding charge appears immediately, sentencing guidelines are unforgiving when a judge concludes a defendant tried to hide evidence or interfere with the process after conviction. The very behavior that was supposed to protect him can add years instead. Reed Talbot, the operations director, caught in the surveillance stills, now becomes a pressure point of his own. So does the cousin on the rental paperwork. So does the driver. So does the assistant, whose number appeared on the help desk call. White-collar defendants often imagine loyalty as a fixed asset. It is not. It is a wasting one. Once the principal is remanded and the government has a fresh map of who moved what and when, the people around him stop calculating friendship and start calculating exposure. And Daniel Voss made that calculation easier for them by answering too cleanly before the record finished unfolding. That is what makes the orange storage key matter. It was never about the price of the object. It was about what the object connected. A hidden unit. Missing records. Witness initials. A backup phone. A post-verdict timeline. A false layer of family distance. One cheap plastic key tied all of it together tightly enough for a judge to stop treating the defendant as manageable. By tonight, Voss would be in intake, not at home. By tomorrow, prosecutors would be expanding search protocols on every device and document trail connected to that unit. By next sentencing date, the case would no longer be about whether he committed procurement fraud. The harder question would be how much extra damage he caused after 12 guilty counts by trying to move the truth one more time. So let me ask you this. Once that orange key turned up and the storage unit started talking, was immediate remand the only outcome left?